welcome to today's webinar. My name is Crystel Rynne and I am the CEO here at HRLocker. I am delighted to have Sarah again with us today on our third and last webinar of the series, Terminating Employment, the Right Way to Avoid a Risk. So Sarah, thank you so much for being with us today. And as always, Sarah, you're in the hot seat today. So if anybody has any questions or wants to interrupt Sarah from speaking, please drop a question in and happy to answer as many. So Sarah, over to you.
Thank you very much. And it is a pleasure to be back with you for this third and final webinar. So we've gone on our employment journey. We've looked at, just trying to move my screen across. We have looked at what we need to do before employment, what we need to consider during employment, and as Crystel said today, is to look at what happens at the end of employment relationship. So I'm going to talk a little bit today about whether that be at the employee's decision or the employer's decision, and some of the factors to have a look at regarding that. So the main point to say before we start really is just that what we're trying to encourage is looking at how you do things and looking at following best practice in what you do. And the reason behind that is not just to save you from legal risks, which it will do, but also to help you kind of from a cultural point of view with your business, leadership from the top, doing things right, and that filters down so that employees are doing things right as well. So I'm going to jump right in, and these are the two kind of areas that we're going to look at, and we're going to go into a bit more detail on each of these in a moment. But first of all, voluntary termination. So this is where the employee terminates the contract in effect. So we're looking at, for example, resignation, retirement, or job abandonment, which basically means they're going AWOL, they're just leaving absent without notice. So there's a few different types, but probably you're quite used to these, you've seen these before. They're hopefully the usual way that the employment relationship ends. So key characteristics around them, usually it's planned by the employee, so you'll know about it hopefully. It's less likely to lead to any legal claims as long as it's handled correctly, so it's a lower risk if the employee is choosing to leave. The caveat to that is if there's a constructive dismissal issue, which we will discuss later. And what we still say is still follow your processes, even if it is a very amicable leaver. Still do your exit interviews and document the reasons why they're leaving. It gives you an opportunity to just see if there were anything that kind of niggled at somebody. You know, it might not be the main reason why they left, but it's always good to get feedback from a leaver, because they usually feel a bit more comfortable to give you some honest feedback at that point. The next kind of termination that we're going to look at is the involuntary termination. So these are where the employer initiates, and usually the employee is not happy that they're being dismissed. So the most common ones are these examples given. So dismissal for misconduct or poor performance, redundancy or layoffs, and then the business closing or restructuring. So usually that will in itself lead to redundancies. So key characteristics in terms of these things to think about and look out for. You need to make sure that you're following a fair procedure. So there's legislation around this in the UK in terms of what is a fair procedure, and some things that under certain termination events need to be done legally, which we'll go into in a moment in a bit more detail. If processes aren't followed correctly, it's likely that the employee may be able to bring a claim for unfair dismissal. So currently they can only do that if they've got 2 years service. It's likely that at some point in the future that's going to be reduced, but at the moment we're at 2 years service. That's not to say we don't have to think about how we do this until they reach that point. It's always best to look at best practice because it gives an impression of your business and how your business behaves. So our advice is always follow that fair procedure. So they may challenge the unfair dismissal. There's processes internally for them to do that through appeal, etc. And then if they're still unhappy and feel that there has been unfairness, then they can go to tribunal, as I've just mentioned. Things to think about when dealing with the termination are around notice periods, final pay, potentially settlement, though that is, I would say, relatively unusual. And again, these are things that we'll go into in a few moments on the rest of the slides. So going back, starting at the voluntary types of termination, I'm going to start with resignation. So what you would expect is for an employee to provide you with a resignation letter. So preferably this is dated, signed, and it states when they are prepared to work to, and hopefully that will set out the notice period. So usually it will say something like, I'm giving you notice now, or my X amount of weeks notice now. Always best to respond to that letter with confirmation that you've received it, and give them details around what their notice period will be, final pay, etc., which we'll go on to at the bottom part of the slide. Just to touch on notice period, so what you would usually agree is that the employee would work their contractual notice. What you might, however, do is agree a different arrangement. So, for example, if you were going to put somebody onto garden leave, or you're going to say you can just go, we don't have a garden leave clause perhaps in the contract, but we'll pay you your notice and we're not expecting you to work, etc. So there are different ways, different things that can be agreed, but the stress really there is on agreement, that those things are agreed. You can't take away somebody's notice period. So if you don't need them to work or don't want them to work, you would still have to pay them that notice period. So some things to consider when looking at resignation. Have you considered handover documentation? So are you prepared for that person to leave? Often you see it that perhaps some businesses are in denial that somebody is leaving and actually don't prepare for it, and it comes as a bit of a shock when they actually do disappear. It's always best to plan ahead, be prepared, and also take into account, the motivation levels of that person are going to dwindle as you get towards the end point. So think about it quite early on in terms of what handover you need to do, what knowledge you need to transfer over to somebody else, or if you're hiring to replace that role, that perhaps that person is involved in that. Exit interview participation, as mentioned in the last slide, getting some honest feedback on experiences and reasons for leaving. It's always useful, and I would stress that it is always useful, even if it feels slightly negative. It is best to get feedback from somebody. Ensure that they've returned all company property, so make sure you know what they have really and what they need to return and when by. Update personal details, so make sure you've got everything up to date essentially, because you will need to be communicating with them during that final period. So have you got their email address? Have you got their home address, phone numbers for the final pay slip to go to? Mention it because sometimes people are moving and that's part of why they've resigned, because they are going elsewhere. So make sure that you've got all your documentation up to date. Make sure that you have kind of tied everything off in terms of, have they done their final timesheet? Have they submitted all their expenses? There's nothing hanging over that would need to be sorted out kind of after they've left. You want to make sure that you've done everything you can prior to that leave date. You may want to talk to them about reference permission, so just clarity on what reference is to be given. What I would say in terms of a reference is I would always, as standard, provide a factual reference. So that will just state the job title and the dates of employment and not really any other information. What they may ask for is a separate personal reference, which you are by all means able to give. I think it's worth just clarifying whether it is a personal reference, whether it is a reference from the business. Just so that they understand the expectation in terms of references. And then access and systems closure planning. So really this is remembering to remove access for somebody, make sure any passwords that need to be changed are changed, etc., so that there can't be any re-entry into the system for whatever reason. So I'm just going to have a look at a couple of case studies on this. So it's going to be a little bit of a you think about it, and then I'll talk through the answer rather than kind of in this setting us having people kind of shout out answers or anything. But just have a look at this case study. So we've got an employee whose notice period is 3 months. They've handed in their resignation, and since then they've had a falling out with a member of the senior leadership team. So they've come to you and said, I'm not going to work my notice. What would you do? So have a think about your kind of what your initial reactions would be to that. And I'm going to bring up some points that I think are worth considering. So, firstly, if somebody refuses to work their notice, they are effectively in breach of contract. So I wouldn't be paying them for that period of notice that they aren't working. That's the initial thing in terms of consequences of that. However, in this particular case, what they have done is stated that there is an issue within the workplace. And in that case, what I would recommend is an investigation to understand what this falling out is. And that's the reason to do that is to make sure that there are no repercussions on the business. Actually, has something inappropriate happened, I would deal with it as you would any employee, whether they were leaving or not. So you would investigate, find out what was going on, and look at what needed to come from that. And it might be that the result of that is that actually you decide to pay that person their notice period, despite them not working it. But that would be your decision as a business. Contractually, you wouldn't have to provide any payment. So second case study for us to have a little look at, and it's a bit of a whiz through these, but on this one, we've got an employee who's been AWOL for a week. So that is absence without authorization and without leave. So they've been off for a week. They haven't communicated anything to you. They've been unresponsive to all communication from you to them. Their emergency contact isn't answering. They have a company laptop and it does have confidential information on it. So what would you do? Is the question. So I'll give you a few moments to think about that before I jump straight in with the answer.
I presume panic isn't the answer, Sarah. No.
Yeah. Try and stay calm. Always the best first point. I should put that actually as first point. Don't panic. There's a solution to everything. Okay. So firstly, I would suggest following your AWOL process. So usually that process will involve making contact, which it looks like you've done. You've tried to contact them. You've tried to contact their emergency contact that you have on file for them. The next step in that process is usually to write to them, to ask them formally to make contact. Then usually send a second letter, again repeating it, asking for contact and stating that you're going to have to look into this as a disciplinary offence if they are not making contact. And then towards the end of that process, once you've sent out these letters and there's been a number of chances for them to make a response, you can look at dismissal through that process. The difficulty with this one is that they have the laptop with confidential information on it. So this would really be, firstly, a conversation with your IT department to find out how you can freeze that laptop, whether you can stop access to that confidential information. And usually most businesses are cloud-based, and so they would be able to do that. So hopefully your worst case scenario is that you have lost a laptop rather than you have also lost the confidential information. So if they moving on to the second point, if they don't respond, do you view this as formal notice, and how would this be communicated? So this reverts back to the AWOL process that we go through. So during those letters that would be sent out, you would be saying, I am presuming by your lack of contact that this is you providing your notice. So there are two ways you could go through the AWOL process. You could take it as a resignation, or you could follow a disciplinary process. Now, most businesses would take it through a disciplinary process, essentially because it's cleaner. You're giving them the opportunity to respond, rather than kind of leaving it open-ended of, have you made this decision, have you not? So once you get to the end of the AWOL process, it will be a confirmed dismissal, and the employee won't have any recourse to come back. Whereas if you're saying, oh, have you resigned, it kind of potentially leaves it a little bit open-ended, and gives them an opportunity to return with whatever reasoning they have. And just a quick note in terms of the AWOL process, in terms of communicating and sending out letters, I would always suggest everything is sent out via post and email, and the post is sent either signed for or recorded, so that at least you have some indication of whether this is received at their end, just for some clarity, really, for yourself. It
Sarah, just
also
on
means,
that, yeah, just on
oh,
that
sorry.
point, Sarah. No, I just have a question here. Is how long would you wait for them to respond before you're trying to contact them again? So you've sent them all the registered letters, you've
Um,
them.
So I would always leave between each letter in the phase. I would always leave 48 hours at least, between them. It gives them an opportunity, sorry, to have received it and be able to make contact with you. So say you're sending it out as a first class letter, they should get it the next day. Then they have another day in order to consider it and provide a response. If you don't get anything after that, those 2 days, then I would send out the next stage letter. So the AWOL process can be moved through quite quickly, which is helpful for a business, given that you are essentially waiting during that period of time. So I would say my expectation is that you could finalise that process comfortably within 2 weeks.
And then I just have one more question here is what about going and knocking on their door?
Um, So it's always a little bit of a difficult one, and it will depend to an extent on the relationship that you have with the employee. It's not something I'd recommend. I think it blurs that line between the professional relationship and actually stepping into a perhaps more personal relationship that isn't appropriate to do by doing that. You might want to put the letter through the post box, say they live close, so their letterbox, sorry, but I would avoid that kind of confrontation, because you don't know the reasons why they've gone, and until they're prepared to share that with you formally, I would avoid those situations that might lead to some kind of confrontation.
And one more question before you move on is what if you know they've left the country?
Still do your process, follow your AWOL process, because you have then, you've got that backup that you did follow your process. They haven't told you that they've left the country, so as far as you're concerned as a business, they should be able to receive this information. What you might want to do, though, if you are very aware, is just make sure you're also contacting them via email and phone each time you send a letter out, to say to them, I have posted you a letter, it has gone to your home address. I appreciate you might not be there to receive it, but if someone's there, they should forward this to you as soon as possible. So it's doing all you can, essentially, but ultimately, unless that employee has permission to not be at work, then they should make themselves available to be able to receive that information from you, and the information you have on file is their home address.
Thanks, Sarah.
Okay. So I'm going to move on to our next type of termination, next type of voluntary termination, and that is retirement. So just to clarify, there is no default retirement age. And you can't use the default retirement age unless it's objectively justified. So put that in there. That is very limited circumstances. So to an extent, ignore that unless you know that it relates to the job role that you're looking at for some reason. I would say, as a standard, there is no default retirement age. So you need to be aware of that, and you need to make sure that employees are aware of that as well, so that if they do want to retire at the age that they'd get their pension, say, that they are communicating that to you and it's not just assumed. So if the next point says follow a fair capability or performance process where applicable, retirement alone is not a lawful dismissal reason. What this sentence is talking about is basically, unless they resign as a retirement as their reason for their resignation, essentially you can't make someone leave for retirement. So if you are trying to remove somebody from your business, retirement isn't an option for you. What you would need to look at is why actually do you want to remove them from the business? Is there a capability issue, a performance issue, etc.? And those are the processes that you would follow. Essentially, their age and retirement age has no bearing at all on any of those decisions. So people will say, I'm retiring, but from a business point of view, it is essentially a resignation. It has no different process to a resignation process, and it can get confusing because people have assumptions around the word retiring, but my advice is just take it as a standard resignation, and the retirement aspect is just their reason for that resignation. So in terms of communicating with the employee, don't assume that someone is going to retire based on age, and equally try and encourage the employees not to assume that you're assuming that they're retiring based on age as well. So to do this, really, it's about keeping up that communication, and we'd encourage regular communication through an employment relationship anyway, which is something we discussed in the previous webinar. But hold regular conversations around career development and what people's plans are. Make sure you always include those older workers that perhaps are indicating they might be looking at retirement. But again, don't make any assumptions. Include them still so that they have that opportunity to talk around their plans. Create a safe place for them to have those kind of conversations. Be open to the conversations around how they are going to ease in potentially to their retirement, or how they want to do handovers, etc. So make the discussions about retirement employee-led. Let them talk about what they want to do and how that will work, and then you can look at how it works as a business, and whether their suggestions are viable or not. Consider flexibility, so consider a phased retirement options, so reducing down their hours, looking at them coming on as a consultant rather than an employed role, so that they've got that option of flexibility. Support the knowledge transfer and succession planning, and this is where conversations are really important, because the knowledge that you will be losing when someone retired can be quite substantial, and it may not be as easy as just a handover document or something like that. You might need to look at how you're going to train their replacement into the role, and it's always best to do that with the help of the person that is leaving. So utilize the knowledge of what's going to be happening, and make sure you're prepared for it. And then just a final point in terms of this is a recommendation to signpost an independent pension and financial advisor for them to look at. So you can't give financial advice. So if they are asking you questions regarding their pension, other than process wise, you shouldn't be answering those questions, because it's a regulated industry. They need to go and get independent financial advice.
Just two quick questions, Sarah. One is so regardless if the contract says that their employment contract says that they retire at 65, we can't enforce that.
Yeah. And if that is the case, if it is in there, I would review the contract, because it shouldn't be in that contract now. Essentially, what will happen is it is essentially redlined out, so it just doesn't work. in the contract, you can't do it, so it's just ignored. But if your contract does contain that, I would suggest reviewing your contracts, because it sounds like it is very out of date. So I'd be a little bit concerned to make sure that there aren't any other clauses in there that are not kind of up to the current legal standards.
And then just one more, which is actually on the AWOL side of things, and sorry I missed it before, was do we continue to pay the employee whilst they are AWOL?
So it's down to you ultimately whether you want to or not. I would suggest not. You can pause their pay, but you can't. So I would pause their pay, but it might be that you will still have to pay them at the end of that process, depending on whether they come back to you. So if you start the AWOL process, you pause the pay, and then they come back to you, you will have to backdate the pay to the what you haven't paid already. So it may be easier for you just to accept that you're paying up till you finalize that process.
Thank you.
Okay. So we're going to move on to the involuntary termination types. I'm going to start off with redundancy. It's something that does unfortunately happen, and it's something that businesses can be quite nervous about. The big point I would make in terms of redundancy, just kind of from an overview, is make sure that you've got all your documentation in place before you start down this path. Make sure you can justify the reason for redundancy, and that you have the correct people that you are applying that redundancy to. So this is the point where I would say get some HR advice to make sure that you are correct in all your processes and what you're doing. What I'm going to talk about here is more redundancy at the point where you're having conversations with the employees, you're interacting with them, and it's looking likely that they are going to be terminated for that reason. So the best approach to take with this is to be very clear in all communications that are going out to somebody, and be empathetic. Bear in mind, this is quite a big change for somebody. They may not have been expecting this to happen. Unlike other forms of dismissal that's involuntary, this might not have been on their radar. So it's important to treat that with some sensitivity. We have a lot of experience with SMEs, and often it's quite a tight-knit community in that workplace environment, and so the impact of a redundancy, even if it's on just one small area, can be seen throughout the business. It can make other employees feel very nervous about their positions as well. So it's not just communication with the individuals involved, it's also thinking about communication with the wider business as well. The kind of the point you want to be at with redundancy, where you want to get to, is that the employees leave with an understanding of why this has had to happen, that they are in full knowledge of all the circumstances, and that you have done everything you can to try and avoid this. That's the ideal point to get to when somebody leaves the business. And how you get to that point really is how you deal with the process, and how transparent you are, how realistic you are in terms of time frames, and clear in your communication. So ensure you plan your process well. Make sure you've got your realistic time frames, and be prepared and open-minded for consultation. And we've put there, it's imperative to consult, and it really is. It's the most important part, because it's where the communication can be really open, and done with individuals as well, where possible, depending on the amount of people that you were looking at being involved in the redundancy scenario. So think about how you're going to make these consultations meaningful. So this is a requirement under the legislation that redundancy consultations be meaningful. But think about what that means for your business. So what does meaningful look like to you? Are you able to be open-minded in looking at alternative roles? Are there, is there scope for that? Are you consulting more on what support you can give to those employees and help for them in the process and in moving on? So perhaps outplacement support, such as CV writing workshops, things like that, can be offered to employees that can really help kind of boost their acceptance of the process and, you know, the business requirements under it. And then just a final point to say, ensure that either they have trade union representatives available, or if you don't recognise a trade union, or they can't, it's very unlikely, but they can't get any reps to you, make sure that you've trained up employees who can act as representatives. So that training will consist of making sure they understand the processes, they understand what support that they should be providing to individuals, etc. And again, that's something that we can help with in terms of providing training for those employees if that is needed for you. Right, so the next type of termination is looking at dismissal. So we're going to look, so this slide, it's to cover misconduct through a disciplinary process and poor performance through either a performance management or a disciplinary process. The slide does, however, focus a little bit on the performance management side of it. So we'll go into a bit of detail on that. So this is, and mainly it focuses on this because this is something that we see a lot of. A real common complaint, particularly from SMEs, is where you have an employee whose performance just isn't where you need it to be. And I think this applies so much to SMEs because usually with the amount of employees that you have, one person who isn't achieving the output that you need has a massive effect on everybody else and the output of the business as a whole. So it is really important. And performance, by performance, we might be looking at their performance in their role. We might be looking at poor attendance, maybe poor attitude. So there's a number of ways, that number of points that come under this performance remit. So looking at performance and how we manage it, we need to make sure that we're following our process correctly. And as with so many things in HR, process, make sure that you're doing what you have said that you will do in your documentation. So you want to have an informal conversation with the employee first. They should be aware that there are issues with their performance. Start with the informal conversations, see if there's improvement just off the back of that. Sometimes people just need to be informed, look, this isn't what I expect of you, this isn't where I expect you to be, and they can themselves step up to where they should be. Sometimes it's not so easy for them and they need more support. And this is where we would look at following a performance management process. Through this process, you'd set out clear objectives that you need somebody to achieve. So your objectives, your goals, how you're expecting them to demonstrate that they've achieved that, and a time scale of when that needs to be done by. This can really be beneficial for somebody if they're not quite sure where they're going wrong and they just need to be able to pinpoint what your expectations are. So you'd monitor this over a period of time. You'd look at their performance. Is it improving? If, unfortunately, you're getting to the point where actually there is no improvement and you don't think that they are going to get to that level that you need them to get to, this is where you can use your performance management process to lead into a disciplinary process. So essentially, they're not performing to the level that is required in the role, and you can look at a disciplinary process off the back of that, which may lead to a dismissal based on that poor performance. So again, there's a process to be followed here. It's not a one meeting and that's that. You need to ensure that you understand what your process sets out and that you're giving them an understanding of what your expectation is for how this process is set out as well. If you don't do this, if you don't follow your process, and if you treat somebody unfairly, then they may have a claim for unfair dismissal. So, and potentially there might be a claim for discrimination in there as well, if they feel that they haven't been given a fair opportunity to improve, they haven't maybe been given reasonable adjustments or whatever it may be due to a discrimination matter. So these are things to be aware of, and this is where these kind of dismissals, if they're not handled appropriately, can lead to serious consequences for the employer, and potentially quite costly consequences as well.
I think that's the key, Sarah, isn't it? Is that you have to follow your process.
It really is, and I bang the drum for process. I really do, because it's a real own goal if you're not following your own process. You know, you've set out that that's what you're going to do. You need to abide by that, and there really is very little justification for not doing that if you've detailed it in your policy documents that is what you will do.
Yeah. I just have one question here as well is, do you have to go through your tiers of warnings before termination for performance?
So generally I'm going to say yes. What you might do though, what you might have is, if you have a performance management process and policy, you might have a reduced disciplinary process for that. So for example, you might have 4 stages for a normal standard misconduct disciplinary process, but performance, you might go, look, it's really critical, and particularly in sales roles, you know, that if we leave this for too long, it's going to have such a detrimental effect. So you can reduce that. So you can start at you might want to change it to a first warning and then a final warning and then dismissal. So reduce it down perhaps slightly, or even potentially start at that final warning, because you're saying, look, your performance is so critical. It will depend slightly on the role, but if you can show that the performance is really business critical, and you need to see improvement quickly, then you potentially can do that. Like I said, it depends what you've got in place in terms of your own policies, but that is something that we can help with as well. But I'd recommend having a separate process for performance management anyway, because it's so specific to the individual. So you need to factor that in. It's not kind of a blanket, or you've done something wrong and this is, you know, the result of that. There does need to be that element of trying to help somebody succeed.
Yeah.
Or
I think
get into that point.
key as well, Sarah, that all of a sudden I can't just meet you and say, by the way, your performance has been really bad the last 6 months.
Yeah.
It has to be documented.
Yeah. You should never be dismissing somebody on the basis of performance and it being a surprise to them. That if that happens, that is a red flag for you, that you haven't followed your process. So to give somebody an opportunity to improve, they need to know what their errors are. They need to know that it isn't what you need it to be. So yeah.
And I think, Sarah, I don't know, would you agree with this? Somebody said this to me years ago, that even if you see an employee stealing something, there is still a process to follow.
Yeah.
You can't.
I work on the basis of, you never know what actually is happening. Even if you think you do, you need to speak to them. You need to understand their side as well, because generally you never know what's going on inside someone's head until you've actually had that conversation.
Yeah. So yeah, process.
So I'm gonna move on to the final type of termination. This is summary dismissal. So this is essentially a gross misconduct dismissal. So because it's gross misconduct, essentially what you're saying is, look, this is so serious that we can't continue to employ you. So you don't go through your stages of disciplinary process that you normally would. You say, this misconduct has had such a detrimental effect that we can no longer have you in the business. And that's why it's summary dismissal, because essentially they go then and there. They don't get their notice. Now, when I say they go then and there, what I mean is, once you've followed your process, when you get to the decision-making point where you can comfortably say, yes, I've looked at everything, and on the balance of what I have in front of me, this person can no longer be in the business, then you dismiss them at that point and they don't get their notice period. So you don't have to pay them notice, they don't get to work notice, etc. So the process to follow in this, again, investigate and do that promptly. You know, you should be demonstrating through your actions that you believe this to be so serious. So leaving it for a few weeks doesn't really kind of chime with that understanding that it is so serious that someone may lose their job. It needs to be dealt with straight away. Suspension. So we would always say suspend only if necessary. It should be on full pay and it doesn't imply guilt. There is a stigma around suspension and people will be feeling that. So it's worth kind of making sure that you're clarifying with them the reasons for the suspension, which is maybe so that you can get your investigation carried out without them speaking to other people that they would inevitably have to do if they were in work. If it involves another person, so that they're not working with that person. Other ways of dealing with it, without actually suspending someone, might be that you move them to a different department, or for example, if they are a driver, then you move them to do something that is not driving, if the breach is something to do with their driving. So it's all about how far do you need to go in terms of the suspension. So try and avoid it if possible, but equally, if it's not safe for somebody to be in work, then they shouldn't be there. And then once you've done your investigation, invite them into a disciplinary hearing. So follow your normal process in this, acknowledge their right to be accompanied, make sure that they've got their invite in writing, make sure they understand why they've been invited, and that they've got your investigation documents for them to look at as well. So anything that's going to be brought up in the meeting, they have the opportunity to look at it so that they can respond to it. And that all kind of goes into this conducting a fair disciplinary hearing. Adjourn your meeting, make sure that you are going over everything that's been discussed. You have a relook at everything, having heard what the individual has to say, and then base your decision on the evidence that you have and the reasonableness of the employee's actions, and also the reasonableness of you taking this step in terms of a dismissal. Once you've made your decision, communicate that in writing. Make sure that they have the right to appeal that decision, which they legally will have. So make sure that you've written to them to inform them of that right. And then keep all your documentation. So if you dismiss somebody for a misconduct issue, whether that be summary dismissal or you've just got to the end of your disciplinary stages process, always keep your documentation for at least 3 months, because the employee has the ability to put in a tribunal claim for 3 months after their date of dismissal. So, I mean, I would keep it slightly longer than that just for comfort, just so that you've got a bit of leeway there. But at the bare minimum, it needs to be kept for 3 months on file. And then you can remove it for under your GDPR processes, etc., which we touched on last week. So the final point is constructive dismissal. So we've put this as type of termination, constructive dismissal. It's not really a type of termination because it is very much shouldn't be happening. It occurs when the employee resigns, but they resign because they felt that they had no option but to resign. So they may not want to resign, but they feel that the employer has, for whatever reason, fundamentally breached their employment contract, so effectively forcing them to leave, so they can no longer maintain the relationship anymore. Examples of constructive dismissal include significantly changing somebody's role, so not consulting with them, not having any conversations, just saying them turning up one day to work and you saying to them, right, today you do this instead, this is your role now. Changing pay, changing hours without having those conversations and getting agreement. This isn't to say you can't make changes to job roles, etc. What it's saying is there is a process that needs to be followed, and if you're not following your process, then that employee can say you've breached my contract, and that is a fundamental breach. bullying and harassment not being addressed, unsafe working conditions, failure to support employees after raising legitimate grievances, etc. So all these points are essentially saying you have not followed your process. And because you haven't followed your process, the employee feels that they have no option but to leave because they don't trust you, essentially, to look after them as an employee anymore. So to prevent constructive dismissal, maintain up-to-date and clear employment contracts. Make sure that the relationship is detailed, as we discussed, I think, in the first of our webinars. This is where it's really important that you have that to go back and look at, that you've set out clearly everything in terms of the relationship between the two parties. Follow fair and transparent grievance process, not just grievance process, every process. Make sure that you are following all your processes fairly and correctly. Make sure that you're communicating, you're consulting where you need to, but also not just where you legally need to, but actually having open communications with people. Make sure your managers are trained. Make sure that they know all of this as well. It's no good you know, being completely up to date on employment law, knowing exactly what to do, but then you're not the person dealing with your employees. Make sure that it's filtering down. And make sure that you've documented everything so that you can prove that you've done everything right and you followed your processes. Right, so finally, just to touch on the actual exit process with an employee. So whether they leave voluntarily or involuntarily, these are the things that you need to make sure you've done, essentially. So make sure that you have issued a formal letter detailing the details of their leaving. So the notice terms, the date that they are leaving, any final payments that might be made to them, any deductions. So for example, if they've overtaken their holiday entitlement, you can claw back some of that. Detail when they're going to receive their P45, etc. Ensure that employees know where to return company property to and what you think they've got as well, because it might be that they have fobs or keys that they've forgotten they have and they need to go and look for those. So you need to make sure you're reminding them of that. And make sure they don't have system access. Now, whether that is from the date that they actually leave or slightly before then, that's a business decision depending on what you feel comfortable with them accessing, bearing in mind that they're leaving. Hold an exit interview, and as I've talked about earlier, it is voluntary, but it's really important to try and do it. And it's something that I think it's a missed trick from a lot of employers, that they don't potentially do that because they don't want to have those conversations around why someone's left. But it really is important to know, but just for your business, so you understand why people might be leaving. Again, make sure that they've been paid correctly when they leave. So you're entitled to make deductions if it's within your contract that you're allowed to do that. So check that you're allowed to make the deductions you're looking to make. So for example, if someone hasn't returned company property, you can take a set amount from their salary, but that should be detailed that you can do that in the contract. Again, it goes back to the contract being there to set expectations so that everyone knows exactly what will happen at each stage. And if there's an issue in terms of payment, so maybe they owe money because they're tied into some training that they've done where they have to pay it back because they're leaving for a certain date, have a conversation with them. If you can't take all of that from their final salary, then can you put in place some kind of payment plan so that you can claw that back from them? I will say it will be a commercial decision at the point that you get to, if someone isn't paying back money owed, as to whether it's worthwhile commercially to go to a debt collector over that, or whether it costs more to go through that process. That will be a commercial decision for that.
Yeah. I have 3 quick questions here for you, Sarah. I think one of them we might take offline, but I'll read it. And is an employee has returned to work earlier this year after an extended period of absence. They've now gone on certified sick leave again, citing acute stress related to personal caregiving responsibilities. However, there are concerns that the employee may be engaging in other activities while on leave, running their own business. the perception is causing tension in the team and their managers pushing for termination?
I think this goes back to a key point around communication. So there is absolutely nothing wrong with you confronting that employee and saying, look, is this happening? You know, I presume there are reasons why you think that that is happening, and you are more than entitled to sit them down, invite them into it, have a conversation, put that to them and say, look, can you tell us, you know, is this something that is happening? Until you do that, it's very difficult to advise and make a decision on what your next steps would be, whether it's something that you know, they're doing something in the evenings that actually is not really a problem, or whether actually they are essentially doing another job while not at work. So it will depend on the circumstances. So my advice would be, first step, call them in and have a conversation with them, put it to them what you suspect, and see where you go from there.
I think you've answered this one already. Is there a legal obligation to do an exit interview? No, but it's good practice, right?
Yeah, exactly. There's no legal obligation. You can't make somebody. Equally, I strongly suggest that you try and invite them to it.
Be surprised what comes back, even if there's feedback on managers, or
Yeah,
perhaps there was an issue with onboarding or something like that. Sometimes you learn some valuable information.
it's surprising the amount of times that actually you get information that you didn't expect, and not necessarily negative, you know, but sometimes it's very interesting to hear what someone thinks when they kind of have nothing to lose, I suppose, from that point of view. You know, they're gone, so they can sometimes feel the ability to be more honest.
Yeah. One more here then, in relation to termination. So is the termination date the day they leave or the date after the week of appeal?
The day they leave. So they will have the chance to appeal. They don't have to appeal. If they appeal and at the end of that appeal the decision is that they should be reinstated, then they would be back paid for that period of time. But off the, you know, the initial decision is that the dismissal is made, it is from that date.
Mhm. And last one then, from a security perspective, we don't allow people to work out their notice period, but we do pay them. Is that okay?
Yes, that's absolutely fine. If you're making the decision that they don't need to come into work, as long as you're paying them, you're not in breach of your contract. So technically you are, because technically part of the employment relationship is that you have work for them to do. But I think it would be, you wouldn't really see someone complaining at that point. I think
Be
that
happy.
they're not allowed to come to work. I think whilst on a technicality, yes, you should provide them work, the reality is that that's not going to, you know, they're not going to complain about that. So as long as you are paying them, then you're not in breach of your obligations under the contract.
Perfect. Thank you, Sarah.
Right, so the final slide I have is just basically a summary here of non-contentious exits versus contentious exits. So non-contentious are peaceful, hopefully. They're low risk. Somebody's made that decision that it's time for them to move on for whatever reason it is. You follow your standard processes that you should have in place for that. They get their normal notice period, and it should be fairly low disruption because you can plan for that leaving because you've got the notice period. Contentious exits are more disruptive. They can be emotional. They can be quite fraught, depending on the reasoning. The legal risks can be high, and part of that is because there's heightened tensions around it. There's feelings that things haven't been done the way they should have been done, maybe, which can prompt people to want to take recourse to the employment tribunal. Not to say that they have, you know, a good reason there, but sometimes the emotions being heightened, they feel that they want to try anyway. So process wise, we need to just make sure that these are, you know, we're being very tight in our processes, and potentially get legal advice if we think that it will go further. We talk here common tools of settlement agreements, or tribunals. So it might be that you feel that somebody maybe hasn't been treated quite the way they should have been. There are flaws in your process, etc. And actually, if they were to go to tribunal, they might be able to make a claim. So it will always come down to, you won't be able to know what a tribunal would decide, because they will look at so many different factors, and ultimately it's 3 people will make that decision based on what they believe. If you wish to avoid going through that process, you can look at coming to a settlement with somebody where essentially you will pay them to revoke their employment rights to take you to tribunal. So essentially you will pay them a certain amount and they will agree that, okay, I will waive my rights, I can't go to tribunal for these things. The only thing you can't do is for personal injury. That's separate. They can't revoke their rights to be able to sue you for any personal injury at work. But that's not really what these are used for. It's more disputes around how somebody has left the business. But the impact of this, unfortunately, is there's high disruption, and potentially there is a cost there as well. So we don't want the contentious exit. Sometimes it's not your choice, it's because the employee has done something and you need to address it. But the main point really is just to make sure, again, following your processes correctly, so that they don't have a comeback to say you've not done things right. And that is me done.
I think if that's the key that you want to leave people on, is follow your processes.
Yes.
If you don't have processes, contact Sarah.
Very much.
Thank you so much, Sarah. It was really helpful. I think sometimes people overcomplicate things about that they're afraid of the process, but it really is just following step 1, step 2, step 3.
And a lot of the time it's your process, so own your process. You've decided that it should look like that ultimately, so it's yours to follow.
Exactly. Thank you very much. As always, we will be sending the recording out, and Sarah's details as well. So if anybody has any processes they want to get done or any specific questions, please contact Sarah directly. But thank you so much. I've really enjoyed the last 3 sessions, and hopefully everybody else has as well. Sarah, you've been great to work with. So like I said, if anybody would like to reach out to Sarah directly, all Sarah's details will be in the email and follow up.
Superb. Thank you very much.
Thank you very much, and take care, everybody.
Thanks.